Court is State versus Walter. Both sides ready to proceed?
Yes, sir.
All right, well, we're ready to listen to arguments on the case, and the appellant will have up to 5 minutes for rebuttal, and both sides will have 15 minutes to present their arguments. Okay, thank you.
Good morning, may it please the court. I'm Attorney Brad Hart. I'm here on behalf of the appellant, Walter. I'd like to start out talking about my first assignment of error with regard to whether there's a plea agreement, whether it was breached, what should happen. Our position is that there was a plea agreement. The state didn't file what was necessary, so we're asking for the court to send this back down for an evidentiary hearing on the plea agreement.
What did it fail to file or follow through on?
Our position is that the state did not file the recommendation for the work release. In this matter, at the sentencing hearing, it was put on the record that Mr. Walter, the appellant, recalled that part of the reason for his plea was recommendation for work release. That was noted by the court. The court did ask the state to file a response. When Mr. Walter filed his motion, and there were 2 motions filed. That's part of the record as well.
But the state did not file a response.
They did not. Yes.
So what was the prejudice to your client other than his hope the state would endorse the agreement?
The prejudice to my client is that the work release was denied, which that is within the purview of the trial court judge. But if it's on the record for something to be filed and there's no objection to that and it's not filed, that's an issue that needs to be done.
Mr. Hart, I know in the brief it says the trial counsel for Tyler stated that part of the agreement for him pleading is that the prosecutor would recommend work release. Are we going to find that attorney stating that on the record, that as part of this plea agreement, Your Honor, the state has agreed to file a motion recommending work release?
No, that's not in the record. Our position is that the agreement should be construed strictly against the state. As I noted in my brief, the case of State versus Nice. With regard to my second assignment of error, discussing ineffective assistance of counsel, I'm not going to spend a lot of time on that. I understand that's a very difficult argument to make. I can see that argument, but I think it should have been raised at the change of plea hearing. That would have been better. Generally, trial counsel would make sure that everything was on the record at that time. That would be the better way to do it. So, I mean, it was raised eventually, but it's sort of, it's on the last page of the last transcript, so could have been done better, but our position is that the required response to the motion for work release wasn't filed, so that's why we're asking for the court to remand this for the evidentiary hearing pursuant to Curry to make sure that both sides can have an opportunity to look at what the agreement was and if it was fulfilled.
May it please the court, Mr. Hart, Nathan Shaker on behalf of the appellee, the state of Ohio. As the court is sentencing in this case. When Mr. Walter entered his guilty plea about the domestic violence and aggravated menacing charge, the only thing put on the record was that the state was dismissing the unlawful restraint charge, and there was no agreement put on the record as to his no contest plea for petty theft. As to the statement made by trial counsel at the end of the sentencing hearing, the distinct language on page 13 of the transcript, I'm going to quote, is, "Your Honor, just for the record, I wanted to mention my client was recollecting that part of the agreement for him pleading was that the prosecutor would recommend work release. I just wanted to state that for the record, I don't have any notes in front of me. I remember talking about work release, but I just wanted to put that on the record." I don't believe that that manifested any agreement, and where that shows are the subsequent motions for work release filed both by trial counsel and Mr. Walter. Neither one of them make any mention of any agreement. So the record is pretty much devoid of evidence of an agreement other than that statement. Based upon that, we don't believe that there's any error in terms of ineffective assistance of counsel or in terms of the trial court's consideration. Unless the court has any questions, the state will rest on the merits of its brief. Thank you.
Counsel for appellant, you do have 5 minutes remaining. If you just want any rebuttal, that's up to you.
With regard to the transcript, I was reading along as counsel was reviewing that, and
What page?
I'm sorry, page 13 that we were looking at with regard to when trial counsel put the agreement on the record. And the trial court does ask counsel for the state to file a response, and the trial counsel said yes, they would. So,
But they're not required to file a response. All they said was they would.
I took it as
You took it as a command from the court?
yes. I took it as that was, but I mean that's the inference that we're drawing, is that that's part of trial court judge's understanding, and that's what the trial court judge was requesting.
What if they just asked him to file a response? Could the response also have been, "We're not recommending work release"?
It could have been, yes.
So any response would have been acceptable.
Yes.
But not silence.
Yes.
Thank you. Counsel, the court will take the matter under